Welcome to the Brews and Appraisal Views podcast, where we blend the art of appraising with a touch of insight and a dash of humor. Whether you're a trainee, a seasoned professional, or just curious about the appraisal world, you've come to the right place. So grab your favorite brew, relax, and join us for some expert tips, real-world stories, and valuable advice to help grow your appraisal business. I'm your host, Dan Lindeman, certified appraiser serving South Florida for over 20 years. Hey, welcome back, appraisers. I think every single appraiser in the country is going to want to hear this next guest. I'm going to introduce him here real quick. Alec Schultz is a partner at Hilgers Law, an experienced trial lawyer based in Miami. He's focusing on high-stakes litigation and appeals. He has represented some of the largest companies in the world and has secured multi-million-dollar judgments in both the courtroom and arbitration. Before entering private practice, Alex served as a law clerk for the U.S. District Judge Donald Milbrooks of the Southern District of Florida. Earlier in his career, he was a counterterrorism officer with the CIA. That is really cool, where he earned the Director's Award for Exceptional Performance. That background gives him a strategic, disciplined approach to litigation, both in the U.S. and internationally. Clients value him for crafting smart, efficient legal strategies that gets results without unnecessary expenses. Welcome, Alec.
Thank you. Appreciate you having me.
So I am in Broward County, and coming across my desk was a class action lawsuit targeted at the AMCs and United Wholesale Mortgage. So that piqued my interest and a lot of appraisers as well. So that's why I wanted to have Alec on. For those people not listening or not familiar with the lawsuit, can you explain some background in it and just go into more detail, please?
No, of course. So this is a class action lawsuit that is really geared toward, obviously, the specific defendants named in this case, but it's really a microcosm case in the macro industry in which you operate, right? Which is the world of appraisals, appraisal management companies, which, as we know, is a multi-billion-dollar a year industry nationwide. And what our case is targeting is this practice where appraisal management companies are acting as intermediaries who, in our view, are really providing de minimis value to the actual consumers paying the appraisal fees. And not only are they providing de minimis value, but they're concurrently driving down the payouts to the actual appraisers doing this appraisal work, which is the entire purpose of a consumer paying the appraisal fee to close the loan. So, we think it's a violation of various state consumer protection statutes. We think it's a negligent misrepresentation on behalf of the lender, in this case, United Wholesale Mortgage, who describes the fee at issue as just an appraisal fee, nothing more, right? There's no disclosure to the consumer about the fact that in many cases, and in our client's case, this appraisal management company is keeping a substantial percentage of what the consumer pays for the appraisal fee, and that their appraiser is only getting a fraction of what the consumer is paying.
So in your case, what was the total fee, if you can recall?
So we have a couple, our client actually had a couple different refis. So there was an appraisal fee that was approximately $600, and then was a little over $700. So, which I think is relatively run of the mill for the industry. We've seen appraisal fees. We're doing some cases in California as well, one against United Wholesale Mortgage, one against Rocket Mortgage, on the same theories, essentially just the California version of state consumer protection statutes. And it seems like most appraisal costs, if there were an average, might be in the $600 to $700 range. Some of our clients that we've seen are paying substantially more if they have a unique property, but even at the low end, they're not insignificant fees.
Right, and the consumer is go ahead and shelling out the money for the appraisal, and in this case, they don't know it went to an AMC, or they're paying this third party, and there's no disclosure about it. Is that right?
No, that's correct. And one wrinkle that we discovered in our investigations, because we're really looking at this as really a nationwide issue, as I mentioned, but many states have a provision in state law that prohibits an AMC from doing what they do in many, many jurisdictions, which is they tell appraisers that you are forbidden from attaching your own personal invoice to an appraisal report, right? So, that struck us as very odd because why would you prohibit disclosure? Well, we come to the conclusion that that's likely because the AMCs don't want the consumer to see, wait a minute, I paid $700 for my appraisal. Why is the appraiser himself or herself only getting $300? Where's my other $400 going? So we think that these statutes are being violated in multiple states as well.
Yeah, there's no reason why they wouldn't want that reported. Let's over-report the details. There's no reason to omit that other than the fact that they don't want to see, like, hey, the consumer paid $1,000 for this appraisal and $700 went to the AMC and $300 went to the appraiser. It's not good, not good. And I know some states do, they do allow, or they actually dictate, like, hey, you can put in the appraisal, like what you were paid for the appraisal, which is good for consumers because, listen, if you're refinancing once every 5 years or you're purchasing a home every 7 years, you're not dealing with the appraisal process often. So this isn't, it's not something that they come in contact to every week, but on a nationwide basis, my goodness, these fees are just being stripped and going to the AMCs and not the actual service provider.
No, you're exactly right. And, one of the ways in which we came across this case was actually my own personal experience is what was one of the factors that initiated our sort of firm investigation of these practices, because I was doing a refi of my own home and I was speaking to the appraiser who came out to the property. And my appraisal cost about $900. And I was just saying to the appraiser, well, it's a solid business model you have here. If you do this many appraisals at $800-900 a week, it's a nice steady business. And he revealed to me, oh no, like you'd be surprised, for this appraisal, I might get $300, right? And that really jumped out to me as like, one of those sort of light bulb moments where it's like, wait a minute, I had no idea who was getting this money, right? He's like, then he said, oh, there's an appraisal management company involved here, et cetera, et cetera. I mean, I'm a lawyer, consider myself a fairly sophisticated person when it comes to, refis and loan closing documents and the like. And I went back and looked at my own documents. There was no disclosure up front about the role of this appraisal management company in my case either. I was simply asked to, pay an appraisal fee with my credit card even before loan closing, right? So if my loan didn't close, I wouldn't even get that money back at all, right? So no. It's not like these are refundable fees. And consumers in the vast majority of cases are made to pay them upfront, which is understandable because you want to pay the appraiser for his or her work. But when you pay an upfront fee with no disclosure, we think that's particularly problematic.
I couldn't agree more. And I guarantee you in your closing documents, all it said was appraisal fee $900. That's probably the only thing listed paid out of closing. This isn't like your house was probably more complex for $900. You're probably in a nice house down there in Miami-Dade. These requests come across my desk like every single day. I see these appraisal management companies sending bid requests, and they put the address, and you look it up. In this house, maybe let's just say it's a $2 million house, really complex, and they're offering $300. Whereas I do a lot of work for attorneys as well outside of lending stuff, and I would charge the consumer probably $900 to do it myself and earn the whole fee because it's a complex job. But this model is incentivizing the AMC to choose the lowest priced appraiser who may be the least qualified just so their profit margin's higher, which is not good.
You're exactly right. And we think that, really this problem, as you just suggested, it almost has, I would call them sort of tentacles that can extend into various parts of the whole, home appraisal process, right? Yes, there's definitely not disclosure to consumers. And yes, the appraisers are having their own fees driven down. But when you are playing to, as you know, sort of effectively trying to play to the lowest common denominator in appraisals, and I know that, there's even a push in some cases for trying to do more desktop appraisals. It's, are you really going back to the problems that were, happening and, leading up to the financial crisis of 2008, right? Where you're taking experienced, more sophisticated appraisers and sort of cutting them out of the market because the fees are so low, right? So what are you getting in terms of quality if you're the lender, and what are you really underwriting here, right? So I think it creates risks that the lenders themselves don't fully appreciate. And, one of the things we're arguing in the litigation we're conducting is that, there are provisions and advisory opinions issued by the Office of the Comptroller of the Currency that say that lenders should be responsible for their agents, which we argue an AMC is their agent for purposes of these transactions. They have to be, fully compliant with all applicable laws and regulations, right? So, we think that the lenders here really need to do a better job also of managing these AMCs. Part of it is, these entities are all very resistant to revealing, even in litigation, how they're operating vis-a-vis each other, right? And I know there's even now certain lenders are trying to take AMCs effectively in-house as wholly owned subsidiaries, which, to your point, can create its own set of problems as well.
So back in the old days before the financial crisis, there's always been AMCs, and some lenders have always hired AMCs just for simplicity. Like, let's offhand the appraisals to this company and they'll just handle it all. But the majority of companies were like mortgage brokers ordering appraisals from appraisers because they knew that appraiser's in their town. They know, like, hey, if it's in my city, Coral Springs, I'm going to hire Dan because he's familiar with this neighborhood. But after Dodd-Frank regulations, most of the lending went towards the AMC model, like, hey, let's offload the appraisal to this AMC function. And now when a mortgage broker orders, they have to order through an AMC, and it doesn't go to me in Coral Springs. It goes to maybe somebody in Miami who's driving up and charging $300, not me who's charging $500. So it definitely doesn't help the consumer, doesn't help the quality. And you mentioned earlier, de minimis value the AMCs provide. So what kind of value do you think they provide? Obviously, there's some little thing there. I'll give credit to the AMCs. There's something there, a little.
No, I mean, you're right. And, with respect to Dodd-Frank, we think one of the things that has happened here is that sort of put appraisal management companies effectively on steroids, right? Because they will take the position that, look, our role is statutorily blessed by Dodd-Frank. And our response to that would be, well, yes, but that doesn't, absolve you from compliance with other federal and state laws, right? The fact that you're permitted to exist and can have a role in this process, it was a well-intended, I think, change in the law, right? Have a what you hope to be a sort of a dispassionate middleman checking appraisals, right? So in terms of the value of the services they provide, I mean, they, of course, will argue that they provide immense services, right? But I mean, it really appears to us like they are, if anything, a method of convenience for the lenders, right? So the lenders can use an AMC, the lenders can therefore comply with Dodd-Frank, and they can sort of say, this AMC is essentially covering our interests under Dodd-Frank and getting us back an appraisal that is, compliant with federal law, right, in terms of independence requirements. I think the reality is that these AMCs have become very good at, forcing appraisers to take less money by using their own market power, right? So if they have the entire market and they're the sort of gatekeepers, as you mentioned, to lender or, mortgage broker work, then, they can use that market power to leverage appraisers to take even less. And, they say they quality control, appraisals that come back from the appraisers, but we haven't really seen a whole lot of evidence of what that really means, right? I mean, it sounds like a value add, but at most, I mean, we really just think these people are, a very, very, very well compensated middleman in the process.
Yeah, and in some cases, earning more than the appraiser is disgusting. They do have they brought on the client. So as an appraiser, you have a steady source of business if it's that client, which is understandable. That should take part of the appraisal fee. Give credit to the AMC for that. But as far as QC work, it's usually the people who are not appraisers who are reviewing these reports and sending back stipulations to the appraiser, which have nothing to do with the value or the quality of the report. It's just that it doesn't fit in their box, and they have these little stipulations that appraisers are required to follow before they'll even get paid, when in fact it doesn't really impact the value of the property or the quality of the appraisal. So in my opinion, working for the AMCs, for the majority of them, is not in my business model, because you're kind of putting yourself at the bottom of the market as fees wise and getting the most amount of stipulations for what? For nothing. So I would agree that de minimis is not much for the AMCs.
And one of the things we've also seen in relation to how AMCs treat appraisers is that, in the vast majority of cases, the appraisers have to sign a contract with the relevant AMC to, have the work stream. And then those contracts will have, very onerous terms as to what an appraiser's rights are if they wanted to, for example, sue or bring a claim against the AMC, right? So they typically have sort of onerous arbitration clauses, which means that an appraiser would have to essentially pay his or her own way, not just to a lawyer, but in arbitration costs as well. They typically have class action waivers in them, so an appraiser could not, aggregate the sort of effective power of multiple appraisers who are, essentially all, I would say, victims of the same kind of conduct on the part of the AMCs. So I really believe that these AMCs have become very effective at leveraging their market power to dominate this industry, certainly to the detriment of consumers and the individual appraisers.
Yeah, and so on a lot of these portals, even if you signed an agreement maybe 5 years ago with them, if you have an ongoing assignment with them and they've updated their terms, you log into that portal, there's nowhere, you can't even do anything until you accept their terms to get to your assignment. Like it's they kind of force your hand, like, hey, if you want to get paid for this, you need to accept these terms.
Right. And again, they essentially can offer those things on a take it or leave it basis, right? I mean, I'm sure there is some level of competition that AMCs have vis-a-vis lenders and mortgage brokers, right? To be one of the AMCs that is funneled business from those lenders. But once they have that business, they really are the gatekeeper, I think, for appraisal work. And they use that effectively, as I said, in many cases by, against consumers by prohibiting appraisers from talking about their own fees, and at the same time, putting relatively onerous, conditions on the appraisers who are working for them with respect to how they are treated and what their, rights and remedies are.
Yeah. So I do some lending work, and I work for one AMC that's owned by a lender. I do work for one of those, but the lender work I do is mostly directly from the lender. So Dodd-Frank didn't say that every lender needs to, hire an AMC. There's still a path where you can still be compliant and have a separate department running the appraisal function. And those, I seem like they're the most successful. Those have the highest quality appraisers working for them because the fees are whatever the consumer's paying. The consumer's paying $600 for the appraisal. It's going right to the appraiser. And it's just the other department not related to the mortgage broker who's dealing with the appraisal function. So there's no collusion in trying to drive values one way or the other. So the possibility of getting away from AMCs from lenders is out there. And there's some lenders who are doing a great job with that. But I think a lot of lenders just, again, you said it earlier, just take the easy way out and just say, yeah, we'll just let them handle it. The AMC handle it.
No, of course. I mean, any large financial institution, if there's a way that they can essentially offload risk, right, or cover themselves from a compliance perspective by using an entity like an AMC, they'll certainly analyze that and see if it makes sense for them. As I mentioned earlier, we do think, though, that in many of these cases, the lenders are effectively failing in their own what we believe is an oversight role that they need to have over the AMCs, right? Because it's not a situation where, in our view, they can simply say, we hired an AMC, we're going to wash our hands of anything that the AMC does, right? Because, from a legal perspective, we think there's a strong argument that they are, in fact, agents for whom the lender is ultimately responsible, right? Because it's the lender who is ordering the appraisal and using the appraisal, relying on the appraisal, et cetera, and the lender who's charging the fee, right? I mean, there's no reason we can think of why a lender couldn't say upfront when describing an appraisal fee, we know the volume of legal terms and conditions that are in loan closing application and closing documents, why you couldn't just add a single provision saying, this appraisal fee could include a separate fee to an appraisal management company as a part of the process, right? And allow a consumer to know that, because it's not as though a consumer has a whole lot of choice in who they pick to do an appraisal, right? In fact, the consumer has no choice. So we don't really understand what the The negative is in more disclosure, but we think it's particularly problematic, and it certainly wouldn't be good for AMC profit margins, I would imagine, if there was more disclosure.
I would totally agree with that. And I think the Uniform Standards of Professional Appraisal Practice, I think an agent is, I think they define like the third party ordering the appraisal as an agent, or that somewhere in the appraisal document somewhere is they do refer to that AMC as an agent of the lender.
Right. So, I mean, and that would in our view, be consistent with how the federal OCC treats the same process. And again, I think that good ideas and well-intended provisions, like we talked about in Dodd-Frank, have essentially in this case in the appraisal industry morphed into in an entire exponentially larger industry of very enriched middlemen, which I don't think Dodd-Frank really intended. Because appraisal fees have certainly risen the last 10 years, and as we said, it's not for many homeowners, it's not sort of an insignificant cost.
Right. So going back to your lawsuit, the Arnold Andrew or Andrew Arnold. So when he got his two appraisals or whatever, and he saw that, what was his reaction to the appraiser in the AMC?
Absolutely. I will speak generally about it because I don't want to inadvertently, talk about anything that would arguably be protected by attorney-client privilege. But suffice to say, as we've set forth in the complaint, he really had no initial idea, and he's a very, smart, savvy guy. He's shopped around for the best lenders, the best rates, et cetera, and but in this closing process, there was no disclosure made to him about this, and upon discovering it after the fact, there was absolutely nothing he could do. Right? I mean, the money had been paid, and there was no recourse, and like all consumers, he wasn't permitted up front or given any sort of options of you could pay $600 and get this appraisal process, or you could pay $500 and get a different appraisal process, or if you have ideas for your own appraisal company you want to use, we'll consider that. Right? This is just a mandatory choice put on consumers by the lender. So he was just kind of your prototypical I would say victim of this process, and especially the fact that he had done two refinancings in short order, right? Because as you all know, it's not like these appraisals only exist for first purchase mortgage. Anytime there's a refi, the lender still wants an appraisal, even if as in our client's case, the previous refi was only maybe 2 years prior.
Yeah. So let's get into some of these examples here. So the ARCC, it's like an appraisal organization that has been documenting a lot of these violations. Appraisers have been sending them lots of documents to kind of validate a lot of this stuff, what we've been talking about. In this one case in Missouri, a borrower paid $1,130 to the appraiser, or to the that's what the borrower paid, but the appraiser only got $220. That's 81% of the fee going to the AMC. Another one in North Carolina, the borrower paid $795. The appraiser got $125. The AMC kept 84% of the fee. And then one thing that stood out, let's see here, was AMCs often take between 40 and 70% of the appraisal fee. And I see this in my own business when these requests come across. It's just ridiculous. I don't know who's working for those lower fees. They're stuck into the system apparently, but that's egregious. They're not offering that much for 70%.
No, that's exactly right. And as we were speaking a few moments ago, we're not going to take the position that an AMC provides literally zero value. There's certainly some, de minimis role that they play. We think it's largely one of convenience. But when you see examples like this, and concurrently you see the practice of the AMCs in, arguably violating all of these state regulations that don't allow them to prohibit appraisers from attaching invoices, it strikes us as a sort of pattern of intentional conduct, right? There's knowledge of what they're supposed to be doing, but they're making, in some cases, a whole lot of money using a system that, limits rather than enables disclosure. And we think that is a pretty prototypical violation of state law. For example, in our cases in California, the state consumer protection law there allows you to base.
You're the same attorney in California. Sorry for interrupting. You're the other lawsuit going on. That's your office doing that?
It is, yes.
Oh, excellent. I didn't know that. Great.
Yeah, so we have cases in California too. We actually had filed those before we filed this particular case in Florida. The defendants tried to move to dismiss. We defeated the motion to dismiss in both cases. So we're beginning the discovery phase of that litigation, where hopefully we'll see a lot more of the inner workings of how this process operates on the AMC side, because as you've probably seen in your business, some of these AMCs have gotten incredibly large and are themselves, close to, if not billion-dollar entities, then, very sophisticated, large companies doing a whole lot of business every single year across the country. And they have their own, effective lobbying group
Right.
that goes around to various states and tries to limit anything that would suggest there's, disclosure rights that appraisers have to attach invoices, or like they argue that, it would create consumer confusion. We don't really know how it would create consumer confusion if consumers are simply told how their money is spent. But that's been the argument that they've tried to raise in various places.
So what's discovery mean? Like, what can you get access to during that discovery process?
Sure. So, in any legal case, what you're trying to see are the sort of internal business documents and decision-making documents, email communications, internal presentations, analyses, et cetera, of how companies, are treating the issues that you've raised in your case, right? So in our cases, we're particularly interested in any documents that talk about AMCs, being aware of these various state requirements, that allow appraisers to attach an invoice if they want to, and how the AMC's conduct is violating those. For the lenders, similar documents, the contracts that they have with AMCs, the AMC's contracts with appraisers, what is in those documents, what awareness do all these companies have of the various legal requirements on them, and then how are they communicating with these AMCs, right? Because we also want to know how various AMCs are hired by lenders, right? What is how are they competing? Are they trying to compete on price? Are they competing on volume? We just don't know all of that yet, and it's going to be very interesting to see how that discovery process plays out.
I can discover it for you right now. It's all about price.
Yeah.
And I'd like to see, I guess, if employees are incentivized for those AMCs to get the most profit margin. Is there any type of incentive for that employee to keep bidding down that appraisal fee just so they make more of a margin? I think that would be really, really telling if you had some of those documents too.
No, that's a great point. The sort of the business model of the AMC internally, and how it operates in conjunction with the regulations that we argue they're, beholden to follow. It would be very interesting because, it certainly would not be out of the realm of the believable to imagine that, it's just in their financial interest, right, to drive down as much as they can what an individual appraiser receives on every appraisal that comes in the door, because the money's not going back to the lender. If there's leftovers, it's staying with the AMC.
Exactly. And so from that study, it says that the AMCs have made over $17 billion. I guess that must be since Dodd-Frank in the last decade. So in the past 10 years, 17 billion. So it's a huge industry. It's a huge industry if that number is accurate.
No, that's exactly right. And I think if you can, we base a lot of our rough numbers off, there's published annual loan volumes on like a state by state basis, right? So when you can see loan volumes, and if you want to just, ballpark, an approximate appraisal price per closing, it'll give you at least something in the realm of reasonable in terms of what what the volume of appraisal work is on an annual basis. And I mean, when we have brought these lawsuits, the appraisal management companies and the lenders are not, they're not bringing in unsophisticated, cheap counsel to defend the claims, right? As you can probably imagine. I mean, they're bringing in very sophisticated, defense lawyers who operate in this space and, make effective arguments for themselves. But I think it shows how both the lenders and the appraisal management companies, have a very strong interest in trying to protect the practice as is.
Got it. So, in your lawsuit, what is the client seeking?
So our clients are essentially seeking financial compensation for what we allege is an overpayment for an appraisal fee, right? So we really are basing a lot of our damages calculations off what the appraiser himself or herself was paid in the actual case, right? Because we think that in a proper way that this should operate is if there's an appraisal fee and it's described only as an appraisal fee, not any disclaimer about the role of an AMC, how part of the money goes there, then the consumer is led to believe that that's where his or her money is going. So when that is not the case, we think there should be repayment of that essentially delta. We're also seeking injunctive relief with the goal of sort of mandating the types of disclosures that we think are necessary here, right? So adjusting how these fees are portrayed to consumers, at the time that they're presented and also at loan closing.
The second part of that, if that's mandated, would be, I think, the end to that industry, that undercutting the prices, because once consumers see that, it's just going to spiral from there. The complaints to the lenders about how, they're paying so much to this third party that I have no control of. So I think that's a big thing, is splitting up that fee and letting the consumers know about it, and will solve the problem.
We really think that's crucial. Again, this issue has come up at the close of the Biden administration, probably the last 6 months of the Biden administration. The Consumer Financial Protection Bureau began an open comment period about the role of appraisal management companies. And a lot of appraisers around the country submitted information to that, which has certainly been derivatively helpful to us in looking at how, sort of extensive these issues are around the country. But I think, again, we view it as, from the lender's perspective, they're collecting the money, but they're not retaining the money, right? It's being passed on. So we think that disclosure by them, to your point, would really go a long way toward, erasing what we think is a, pretty clear intentional lack of knowledge on consumers' parts.
Got it. So a class action lawsuit. So does that mean you're looking for more instances of this where people want to join the class action lawsuit? What is that? What is a class action lawsuit?
Yeah, no, great question. So a couple of different things. I mean, our class actions are led by what is called the named plaintiff, right? So in our case, Mr. Arnold. So Mr. Arnold is standing in sort of his own shoes, and he's acting as a representative for any other individuals who had the same circumstances as him during the sort of statute of limitations period for the claims that he's bringing, right? So anybody else similarly situated who used these same appraisal management companies and had the same practice of non-disclosure applied to them. That's the same with our California cases. So as the case progresses, it's not uncommon for us to have people who reach out who also want to be added as named plaintiffs. This case is pending in state court. It's pretty early stages, so it's not uncommon of amendments to the complaint to add more individuals. But as we proceed now, it would be essentially a class of individuals in Florida who fit essentially the same, I'll call it, profile as Mr. Arnold in terms of their dealings with the appraisal management companies.
All right. So so you have the two AMCs that you're have the class action lawsuit for. How do you get more plaintiffs? Is that a good thing when more plaintiffs sign on for it? How do you find them? Like, how do you reach out to them?
No, a lot of people reach out simply by seeing the case in the news. So, if you can honestly run a Google search, and the case might pop up with a sort of excerpt of the complaint and the contact information from the lawyers. So between this case and our cases in California, we've heard from probably, I would say, dozens of individuals, both appraisers and consumers across the country, who've reached out, asking questions, saying, oh, I have this knowledge of this appraisal management company. Would you like to, I need to tell you about it, et cetera. So it really kind of, I feel like, social media and the internet are a powerful disbursement mechanism for information, right? So I think that's how, we have talked to a lot of people enjoying the case. And it's not like a situation where, we are actively looking for more class representatives, because again, as the law works, Mr. Arnold can stand in the shoes of all of them. But a lot of people feel very strongly about what they believe is misconduct that they were subject to, and like to add their names as additional named plaintiffs. So that's something that is certainly not uncommon when we do cases like this.
All right. And I know you're coming up against a hard stop here, but last question is your confidence level in the case.
Oh, great question. I would say that, we believe we've identified conduct that is not compatible with the relevant laws that we've brought. So, we'll aggressively advocate for that in front of the various courts around the country. As I said, in California, the presiding judges, the two different judges in two different courts, both allowed the core of our claims to proceed, passed the motion to dismiss, so found that they had legal merit. We think the same thing will hopefully apply to Mr. Arnold's case here in California. We're actively investigating, bringing actions in other jurisdictions as well. So, again, when you have a pretty clear pattern of non-disclosure, we think it presents a pretty compelling legal story.
Awesome. And if appraisers or anybody listening wants to get a hold of you, what's the best way they can reach out to you?
No, I appreciate that. Of course. Always happy to listen to industry experts and those around. So my email is just aschultz@hilgerslaw.com. And that's probably the easiest way to reach me. Lawyers are neurotic about checking emails, sure. And I'm in and out of the office a lot for court, so easier than phone calls, and I can circle back with people.
Got it. All right. I really appreciate you coming on today. This is an excellent topic. I think appraisers are going to enjoy, and let's hope to see some change out of it. So you have my support. I'm sure you have a lot of other appraisers' support. So with that, appraisers, I'll catch you on the next episode. Thank you very much, Alec.
Thank you.
Thanks for joining us on the Brews and Appraisal Views podcast. I hope you enjoyed this episode and found some value in it, which you can apply to your appraisal business. If you enjoyed it, please subscribe and leave a review. It really helps us reach more appraisers like you. For more tips and to connect with other appraisers, visit referappraisals.com. Until next time, keep brewing up success in your business, and I'll catch you on the next episode.